Official good morning and welcome to this webinar. Please note you are welcome to pose questions. It has to be done on the Advocate Muhammad Abduroaf Facebook page. This webinar is streamed on various other platforms as well. However, I'm looking at the Advocate Muhammad Abduroaf Facebook page, and that is where I will be receiving questions from, and I'll be posting it onto the whiteboard. But for now, the topic is parental rights of grandparents to minor children. You can extend it to parental rights of aunts, uncles, and other family members, step-parents, etc. To start with this topic, one needs to determine, I think you first want to know whether or not they have inherent parental rights and responsibilities over the grandchildren. The answer is no. Only parents have parental rights over their minor children, not grandparents, not aunts, not uncles, not step-parents by default. And in order for a father to have parental rights over a minor child, the child should firstly be born from a marriage, or the father should have been involved in a minor child's life. So by default, it does not mean every father out there automatically has parental rights and responsibilities over their specific minor children, respective minor children. If you were married to the mother, wonderful, automatically you have it. However, if you made the mother pregnant and you went missing and you nowhere to be found, you do not have any parental rights and responsibilities. If you were married to the mother, if you're missing, you automatically still have parental rights and responsibilities. So we will unpack that today. As mentioned, if you have any specific questions regarding this topic, the parental rights of third parties, grandparents we are using for the specific example, you are welcome to pose it and I shall try my best to deal with it. I'll be keeping a close look at our Advocate Muhammad Abduroaf Facebook Live page. And at that specific page you can and you may pose specific questions regarding this topic. If you have any other questions regarding parental rights, not necessarily grandparents or aunts or uncles and so on, you're welcome to post it on the Advocate Muhammad Abduroaf Facebook page and I will post it or paste it onto the whiteboard. That's a whiteboard, but for now we are using PDF or the Children's Act in its place. Let us begin. Continuing from what I mentioned earlier on, in order for you to have parental rights and responsibilities, you have to be the parents of the minor child. Alternative, and if you were not married to the mother, you will have to acquire it, you have to attain it. But by default, when you're married to the mother, automatically you have parental rights, etc. All mothers have parental rights over their minor children. That's just it. There's no way around that. But when it comes to fathers, we have to ask a few questions. Were you married to the mother? Were you involved in the child's life, etc.? Let us move on to the Children's Act. That's our point or port of call, what we'll deal with first. Chapter 3, Parental Rights, Parental Responsibilities and Rights. Acquisition and loss of parental rights, parental responsibilities and rights, excuse me. Section 18, that's the section we generally look at. It says the following: a person may have either full or specific parental responsibilities and rights in respect of a child. The parental responsibilities and rights that a person may have in respect of a child include the responsibility and the right to care for the child, to maintain contact, to act as guardian, to contribute to maintenance, etc. Then it goes further and says, subject to subsection 4 and 5, a parent or other person who acts as guardian of a child must administer and safeguard the child's property, assist or represent the child in administrative, contractual, and legal matters, give or refuse consent for the following: marriage, adoption, departure of the republic, or coming back, or removal, consent to the child's application for a passport, consent for the alienation of immovable property. So if the child wants to sell property, you need consent of the guardians. And it goes further, a court can override the consent of either parent. Then the Children's Act, it unpacks the various forms of parental rights and responsibilities. Section 19, parental responsibilities and rights of mothers. It basically says that all mothers have full parental responsibilities and rights over the minor child. If the biological mother of the child is unmarried child, who does not have guardianship in respect of the child, and the biological father of the child does not have guardianship in respect of the child, the guardian of the child's biological mother is also the guardian of the child. So that basically means if the child is young, 16 years old, 15 years old, and has a child, automatically her parents have guardianship rights as well over the grandchild. But that's not the topic of discussion today. Here we go. Section 20, Parental Responsibility and Rights of Married Fathers. I must just ensure that you can see exactly what I can see. The font is a bit small on my side. I have to zoom my eyes into it, so I apologize for any stutter on my side. And a second question also came in, but let us first deal with the section. Section 20 of the Children's Act. Parental responsibilities and rights of married fathers. What does it say? The biological father of a child has full parental responsibilities and rights of the child if he is married to the child's mother, or if he was married to the child's mother at the time of the child's conception, at the time of the child's birth, or any time between the child's conception and birth. So if he made the mother pregnant and he divorced the mother before she gave birth, he has full parental, the father automatically has full parental rights and responsibilities. If he was not married to the mother when the mother fell pregnant, but he married the mother afterwards, automatically has full parental responsibilities and rights. That section is self-explanatory, but it basically explains if you're married to the mother, wonderful, there won't be much discussion regarding your parental rights. Section 21, that's the most interesting part of this discussion. Parental responsibilities and rights of unmarried fathers. That is obviously something which I deal with regularly. Many people that have kids, they do not first get married. It happens all the time, and it might have applied to you. What does it say? The biological father of a child who does not have parental responsibilities and rights in respect of the child in terms of section 20, meaning married to the mom, etc., acquires full parental responsibility and rights in respect of the child if at the time of the child's birth he is living with the mother in a permanent life partnership. So he did not want to get married to the mother, but they are living almost as husband and wife. Or if, regardless of whether he has lived or is living with a mother, consents to be identified or successfully applies in terms of section 26 to be identified as the child's father, or pays damages in terms of the customary law. That is self-explanatory but technical, not something which I deal with regularly. I deal basically with the next two. Contributes or has attempted in good faith to contribute to the child's upbringing for a reasonable period, and contributes or has attempted in good faith to contribute towards the expenses in connection with the maintenance of the child for a reasonable period. Basically, he was involved in the child's life. He paid maintenance, he formed part of the child's life, etc. Automatically, he would acquire parental rights and responsibilities over the minor child. This section does not affect the duty of a father to contribute towards the maintenance of the child. Therefore, even if a father acquired no parental rights and responsibilities of the minor child, the mother fell pregnant, the father went missing, or he was not involved in the child's life, he still has a legal obligation to pay maintenance. And it goes further, if there is a dispute between the biological father referred to as subsection 1 and the biological mother of the child with regard to the fulfillment of that father of the conditions set out in subsection 1A or B, the matter must be referred for mediation to the family advocate, social worker, social services, professional or other suitably qualified person to determine whether or not he has acquired those rights, whether or not he was involved in the child's life, partook in the child's life, etc. And I think that explains the issue concerning parental rights and responsibilities of parents in relation to the minor children. If you're married, wonderful, you have full parental rights and responsibilities. If you're not married, you will acquire that if you partake and you form part of the child's life. If there's a dispute, you need to go for mediation, and the mediator will hopefully try to resolve that specific issue. Section 22, very interesting section. Not part of my discussion today. It deals with a parental responsibilities and rights agreement, whereby if you have parental rights, you can assign it to a third party. I will leave that for another day. You're welcome to have a look at that yourself. I am not dealing with that today. It might just confuse my other part of the topic, meaning dealing with the assignment of contact and care rights to interested persons by an order of court. So basically what I'm trying to bring to your attention today, and considering the topic, parental rights of grandparents and minor children, The question is posed, do they have any parental rights? The answer is no. Only mother and father is mentioned. If you look at the entire Children's Act, there's no mention about aunt, uncle, grandfather, grandmother, sister, or brother. You only see the terms mother or father, and that's what you see. Grandparents does not feature. Therefore, in answering your question, yes, as I mentioned earlier on, by default, grandparents do not have any parental rights and responsibilities over a minor child, but they can acquire it if it is in the child's best interest. And that's where Section 23 of the Children's Act come to operation. The previous section, Section 21, you can see it's by agreement, which I'm not dealing here with today. Of course, parties can come to an agreement, and they can have that agreement registered at the Office of the Family Advocate, or they can have it made an order of court. That's something else. But here we're dealing with a scenario. Let me give you a fictitious scenario. Mother fell pregnant. She's quite young, over 18, but she's quite young. And she leaves the child with the grandparents to take care of the grandchild. They care for her, the mother. Maybe the father is also a bit involved in the child's life, etc. Time goes on, mother catches on some nonsense, she goes missing, whatever the case may be. She's unable to care for the child. She might be on drugs, she might be, but there's some issues involved, whatever the case may be. And now she maybe says, I do not want the grandparents to anymore partake in the minor child's life. Alternatively, she wants to limit the grandparents' involvement in the child's life, whatever the case may be. The grandparents are saying, no, we looked after the child for the last 7 years. We taught him to walk, we potty trained him, we fed him, etc. The mother was never there. She was always out partying with her friends and enjoying life, and we were having to deal with the brunt of this. Now, all of a sudden, the mother now found a new boyfriend, and she now wants to leave. She wants to go now to a different province. What can the grandparents do? No, they can't do anything much. They're not the parents of the child. They're the grandparents. They're supposed to enjoy grandchildren. They're not here to become parents again. But they are concerned about this child. They are concerned that if the child continues to live with the mother or with the father, depending upon the facts of the matter, the child will be neglected. The child's best interest won't be upheld because they care for the child. Then they will approach the court, and the court can assign parental rights to the minor child. Alternatively, what do I mean? What do I mean by parental rights? The court can make an order that the grandparents can have contact rights with the child. So the mother must bring the child once a week or every few days to the grandparents' home so they can have continuous contact with the child. Alternatively, the court can make an order that the grandparents are the minor child's primary caregiver. The child should reside with the grandparents and not with the mother, although they are not the parents of the child. Alternatively, the court can even go further and make an order that the grandparents now become the child's guardians. So, if the child has to attend school at the age of 6 or 7, and they make an application to the school, they'll ask, okay, you are old, you're grandparents, you got a bit grey, the child is very young, the child is 6 years old, and you guys are in your 70s, so whatever the case may be, they can bring out a court order stipulating, we have been assigned guardianship rights over the minor child, the sole guardianship rights. So that's where I'm going to with a specific topic. I do see the questions that have come in. There are now 2 questions that have come in, and I will deal with those questions soon after I deal with this assignment, section 23, and there is also section 24. Therefore, when applying the section, it says any person having an interest in the care, well-being, or development of a child may apply to the High Court, a divorce court in divorce matters. That would apply, for example, if there's a step-parent involved, and the step-parent was well involved in the child's life, and now the parents are divorcing. Now this couple is divorcing, meaning that the step-parent will basically not have any say over the child's life or communication or contact with this child because he's a step-parent. And being a step-parent doesn't afford you any parental rights. Then the step-parent will say, okay, I'm divorcing the mother, but there's a child involved here as well, my stepchild. I would like to continue having contact with the specific child. So I'm just interluding there. That's where you'll deal with the situation in a divorce court. Or the children's court, for an order granting the applicant on such conditions as the court may deem necessary, contact with the child, or contact or care of the child. So contact meaning you visit the child, he or she will see the child every now and again, or care of the child meaning the child will be in the care of the grandparents or the third party. And then we deal with subsection 2. When considering an application contemplated in subsection 1, the court must take into account the best interest of the child, that's always a fact, the relationship between the applicant and the child, and any other relevant person and the child. Very important. So we look at the grandparents, we look at the parents as well. The degree of commitment that the applicant has shown towards the child. In our fictitious scenario, they looked after the child for the first 6 years of his life, potty trained him, took him to preschool, whatever the case may be. The extent to which the applicant has contributed towards the expenses in connection with the birth and maintenance of the child. Here, the grandparents might not have paid for the birthing of the child, it's possible, but they have maintained the child. They've paid for everything. And any other fact that should, in the opinion of the court, be taken into account. One fact would obviously be that the mother is neglecting the child. Subsection 3, if in the course of the court proceedings it is brought to the attention of the court that an application for the adoption of the child has been made by another applicant, the court must request the family advocate investigate, etc., etc., etc. Doesn't apply to our scenario. And subsection 4, the granting of care or contact to a person in terms of the section does not affect the parental responsibility rights that any other person may have in respect of the child. So in our specific scenario, if the father had contact rights to the minor child, parental rights and responsibilities of guardianship rights, and now the grandparents acquire the specific rights, it doesn't take the father's rights away. He should continue partaking in the minor child's life, unless the court specifically makes such an order. The court can make such an order. You can limit the other parent's parental rights and responsibilities of the minor child. So in our fictitious scenario, the end of this whole process, 4 people will have parental rights and responsibilities over the minor child. Mom and dad, by default, in terms of section 18, which we mentioned earlier on in the Children's Act, and grandma and granddad, because they have applied, the court assigned parental rights and responsibilities of care or contact, whatever the case may be. Let us see what's happening. Okay, we see more questions. I think there's a third question that came in now. Wonderful. I will deal with that as well. I think I need a bigger screen. And now we're dealing with another scenario. So care and contact, that's day-to-day, how can I say, day-to-day caring for the child, as opposed to guardianship rights. So care deals with the issue concerning where the child sleeps, taking the child to school, bringing the child back, attending to homework, extramural activities, having fun with the child. Contact can be the same, but care basically means the child stays with you and you're caring for the child, like any parenthood. Contact, obviously, the child goes to you for a shorter period of time. But that's that aspect, the day-to-day activities of the child. Guardianship rights, again, as we mentioned early on, applying for a passport, contractual agreements, medical procedures possibly, the child leaving the country, coming back into the country, but selling his property, alienation of immovable property, etc. So that's where guardianship rights comes in. Now, here we have this fictitious scenario of the grandparents, whereby they've acquired parental rights and responsibilities of care and contact. But what about the guardianship rights? Now they have to take the child to a preschool, to a primary school, to a high school, take the child overseas, on holiday, etc. Now they're limited still because they always have to get the parents' consent, but the parents are never available, they're missing, and they're not forming part of the child's life. Alternatively, the child might have to do some things, get consent from the parents for extramural activities, to go on excursions, etc. And they're not guardians, they have care and contact rights, but they're not guardians. So what does it say? Section 24, assignment of guardianship by order of court. Any person having an interest in the care, well-being and development of a child may apply to the High Court for an order granting guardianship of the child to the applicant. Very important to note here, what are we seeing here? We're only seeing High Court. We're not seeing divorce court or children's court. So when it comes to guardianship rights, only the High Court can assign guardianship rights to third parties. Of course, they can assign guardianship rights to, the Children's Court can assign contact rights to step parents and third parties. But when it comes to guardianship rights, only the High Court can deal with that. And the problem I have with that specific section is it can become very expensive because it causes people, it forces them to go to the High Court. Why can't they go to the Children's Court? That's my question. I see no logic behind this, but that's what the legislature intended, explicitly intended. And now, what are the considerations? When considering an application contemplated in subsection 1, the court must take into account the best interest of the child, the relationship between the applicant and the child, and any other relevant person and the child. Here we deal with the grandparents. They've always been involved in the child's life. Any other fact that should, in the opinion of the court, be taken into consideration? Yes, one fact. We cannot get hold of these parents. They are on drugs. They're always missing. They're always acrimonious. They themselves can't decide what school the child should go to. How can we as grandparents still get involved with them? So the court will give you that specific authority. In the event of a person applying for guardianship of a child that already has a guardian, the applicant must submit reasons as to why the child's existing guardian is not suitable to have guardianship in respect of the child. Yeah, because the mother is on drugs, she's always on the move, she's never available, etc. There it is. What have we concluded here? That all mothers have automatic parental rights and responsibilities. Fathers, if they were married. If they were not married, they can acquire if they are involved in a child's life. Grandparents, aunts and uncles do not have any parental rights and responsibilities, but they can acquire it and the court can give it to them if it is in the child's best interest. That's the long and the short of this. I hope you've benefited from that, and let's get to the whiteboard and take off the Children's Act from our screen. There we go. And we have some questions. Let me get to those questions, and that's why we are here today. I have to copy and paste from Facebook. So question 1. Oops. Let me get to question 2. I'll deal with them after each other. Sorry about this. These questions are live. Well, there's quite a few. And question 3, they will take it from there. Oops. There's 5 questions in total. I shall deal with these questions first. The first question goes as follows. How is the father's involvement in a minor child's life established? It's a factual thing. The mother might come and say, no, the father was never involved with the child's life. But the father said, no, I was involved in the child's life. I tried my best, but you refused me to partake in the child's life, etc. So it's a factual thing. Every case is different. It depends on a lot of factors. If the father lives in a different province, has he continuously tried to contact the mother, try to make Zoom calls, Facebook Live, whatever the case may be, whatever people might decide to use. It's a factual thing and a decision and a fact which the court has to, or the party will have to decide, objectively speaking, relevant to the party's situation. So even if you do not have that specific involvement, but you have attempted in good faith, but the mother is now stopping you from doing so, you can still acquire those parental rights and responsibilities. The challenge is, it's an academic question because the father is now coming to the table and he's saying, I would like to form part of the child's life. Yes, there's a dispute. The dispute might go to the family advocate's office. But at some point, for a short period of time, he is now involved in the child's life. So it's very difficult to not acquire parental rights and responsibilities if now you're coming to the table and you're saying, I now want to form part of the child's life. So how is the father's involvement in the child's life established? It's an objective question and depends upon the specific circumstances of every case. If a reasonable person can say, no, man, this guy is attempting, he wants to be in the child's life. He is here today in the mediation session. Clearly, he is, and he wants to be involved in the child's life. That is objective fact, and we will have to take that into consideration. I will answer that specific question. Question number 2, I have a husband that don't want 50-50. So 50-50, I presume, would be 50% contact. So I presume that the mother is caring for the child, but the father does not want to equally share in the child's life. That is a very sad thing, and I always have this query and this problem, whereby the law cannot force someone to love and to want to take part in the child's life, and that's unfortunate. The law can force someone to pay child maintenance. The law can punish you for limiting contact to the child from the other party. So if you have primary care over the minor child and the other party needs to have contact and you are limiting contact, the court can force you to give the child over. That's what the law can do. But the law unfortunately cannot force someone to love a child and to be involved in the child's life. I always say, under these circumstances, then you are lucky, because now you can give more love to the child can give more love to you. I do not know how to answer that specific question. The bottom line is, I could say, maybe go for parenting counseling, sit with a professional, unpack your issue, saying the father, discuss the issues. Your problem is the father is not much involved in the child's life. Let this expert try to advise and assist the parties and see how it has an effect on the child's life. The third question. My ex-wife keeps my son over from me for more than 2 months. I would say, I presume, away from me for the last 2 months. I sent her my son's money every once still, but she doesn't want to give in. What can I do, as she is just rude to everyone? So I presume you paying child maintenance, but the mother does not want to send the child over. The long and the short of the matter is, this matter must go to court. I would advise you to maybe see an attorney, to send them a letter. Alternatively, go to the children's court and they can enforce this. If the children's court looks into this matter, they listen to both sides of the story and they come to a decision, no, the father, there's nothing to stop or nothing limiting the father of exercising his inherent right to have contact with the child. The person, say my ex-wife, so automatically has full parental rights and responsibilities. If there is a court order in place, the mother is in contempt of court. So I would advise you to enforce your rights in terms of the order. Go to the children's court, see an attorney, and do something about it. I hope that answers that specific question. Question number 4, our next one, let us deal with that. And we have question number 5. We get to that one, and then if there are any additional questions, you're welcome to post it. And let's deal with it in that specific fashion. Let's move up. Question number 4. She doesn't want me to pay for him, as she wants to go to court and get sole custody over him. That happens quite often, where the mother says, you know, I do not want your money, but I want to have sole custody over the child. I do not want to have any contact. I do not want you to have any contact with the child. You want to give money, but no, keep your money. I'm happy if you have no contact with the child. That is not in the child's best interest, and nobody really benefits from such a situation. It causes acrimony between the parents, number one. That's not good for the child. Clearly not. Mothers and fathers should at least act civil with each other. If they're not truly civil with each other, they need to act civil with each other, and that will benefit the child. And a child not having contact with the other parent, obviously, that is not in the child's best interest. A child needs to know who the parents are, even if the other parent is not so the perfect parent. Here, he or she has certain issues. It's part of life. You have both parents in your lives. So, long story short, if the mother goes to court, you can show the court, you can tell the court, I have continued to try to pay the child maintenance. Put maintenance into a trust account, speak to an attorney, open up a trust, or open up a bank account, put all the money in there, and once this matter gets resolved in the children's court, whatever the case may be, you can say, I have tried, I have attempted to pay child maintenance. The mother did not want it, but every mother put aside a sum of money. This money belongs to the child. Create an educational policy, whatever is allowed and to the child's best interest. Remember, any party can take a matter to the court. You can ask the court for anything. In a maintenance inquiry, you can ask the court for R1 million per month. The question is whether or not you will get it. That's something else. In our scenario, in the specific questionnaire scenario, the mother might be saying, I would like to apply for sole custody. Whether or not she gets it, that's something else. She's welcome to type in a piece of paper, write in a piece of paper, I want sole custody. The court sees what she wants. The court will only give her what she wants if it is in the child's best interest. And the last question I have here, I always double check if it applies to someone else. If it's a second question or not. No, this is the first question, first time question. My son unfortunately doesn't know his biological father, as he still doesn't make time for him, but the father has started paying maintenance again after stopping for a few years. I would like to know if he has a right to want to have our son visit him without presence. You see, when it comes to these type of scenarios, maintenance and contact and care are two separate issues. But we have to look at what is best for the child. And you're asking me the question here whether or not he has a right to have unsupervised contact. I think that is what you mean with regard to without presence. I do not believe a parent should have supervised contact. I do not know, depending upon the age of the child. If the child is 3 years old or 4 years old, doesn't know the other parent, maybe a supervised would be a good idea. But how do you bond with your child? I mean, how do you, it's like two friends are spending time together, but they're always being watched by a third party. Yes, maybe initially contact should be supervised, but at some point it has to be unsupervised. And that is when people start bonding, when people aren't watching, because now it's bonding with the child cries, and the other parent comes and says, yeah, why is the child crying? Scold you out, But of course, many times the child's alone with you and you're the primary caregiver, the child cries. So I focus on what is best for the child. If a party wants to now, a few years later, be involved in the child's life, that is great, that's wonderful. If it will not detrimentally affect the child, it needs to take place. I would say you're lucky. You can avoid the child from having contact with the other parent for years. The child turns 18 years old, he or she might resent you. Why have you limited me having contact with the child? Yes, the whole debate will be, but your father wasn't there, your mother wasn't there, etc. But at the end of the day, parents need to come together and try to work on having some type of civility and having both parents involved in the child's life. But applying my question to you, if the father has not paid maintenance, he has to pay maintenance, and you need to take him to the maintenance court. He needs to be put to task regarding that. And if he or she is now willing to have contact with the child, any court of law will not limit a parent to have contact with the child unless there are very good reasons for so. There should be very good reasons. And if it means maybe starting off with supervised contact because the child doesn't know the parent, the court will do that. But at some point, contact will have to be unsupervised. Yes, I see the person said here without me being there. That's what the questioner was referring to, without me being there. So it must be supervised contact without the other parent being there. The question is, must the other parent be there? Will the child be in danger? You can take the parent to a public place, to a shopping mall where there's a play area. Go for a McDonald's ice cream. Let them bond. I do not see how people can bond if you're always being watched by another person. But remember, the child's best interest. If it is in the child's best interest, wonderful. Contact should be supervised. But it's not always in the child's best interest for contact to be supervised. That's all that I'm saying on this specific topic. Ladies and gentlemen, I see no additional questions. Thank you very much for your time. I hope you enjoyed the video. And if you're watching this video later on, please feel free to share it. And I hope to see you on our next live webinar on Facebook Live. Have a lovely day, and I shall see you soon.